Sometimes, when you're in the US, you're eligible to apply for adjustment of status, and along with that package, we can include an I-130 family petition. Hey guys, welcome back. I recently hired a new employee and have been trying to train him on the ins and outs of immigration law. And after a few days of training, he pulls me to the side and he asks me, "Can you explain the difference between an I-130 family petition and adjustment of status or a green card application?" And I stopped for a second and thought, this is a really basic question. He should know the answer to this by now. But as I thought about it further, I realized, okay, immigration law is way more complicated than I'm acknowledging. I've been doing this for many years, and I should just take the time to explain it to him. And then I thought, why don't I make a video on the topic? Because if he has this question, you guys might also have this question. So that's the purpose of today's video and what we will be discussing. Let's start with, what is an I-130 petition? An I-130 is a form that you file to petition for a family member to become a permanent resident of the United States. But it's actually not exactly a pathway to permanent residence. What it is a prerequisite for applying for permanent residence in the United States. So, for example, if I want to become a permanent resident in the United States, before I can apply for permanent residence, I need an approved family petition to show that I meet the requirements, the prerequisites. Once I have an approved family petition, I can then apply for adjustment of status or permanent residence, also known as a green card application. But it actually gets more complicated than that. Sometimes, when you're in the US, you're eligible to apply for adjustment of status, and along with that package, we can include an I-130 family petition. In that case, you don't have to wait for the family petition to get approved first. We could just apply for the whole package right away, which will include the I-130 family petition. But sometimes you can only file the I-130. Sometimes you are not eligible to apply for adjustment of status. A clear example is a sibling petition. If you file a petition for your sibling, they're not eligible to adjust status, which is applying for a green card within the United States. They must go outside of the US, which is not called adjustment of status. That's called consular processing. That's a different process. So basically, if you're petitioning for someone, they might either be eligible for adjustment of status, or they might have to go outside of the US to a consulate to finish processing so that they could re-enter as a permanent resident. Let's look at a small example. Let's say that you are a US citizen and your immigrant spouse entered the US with a visa. Now, after speaking with a lawyer, you are told that you are eligible to apply for adjustment of status for your spouse. What does that mean? That means we file the family petition and the green card application all at once. Inside the United States, your spouse does not need to leave the US, and your spouse will become a permanent resident within the United States. But now let's look at a slightly different example. Let's say you're a US citizen, but your spouse entered the US without a visa, crossed the border, or doesn't have proof of being legally admitted into the US. In that case, we would not apply for adjustment of status. We would only file one of the forms in the adjustment of status package, the I-130 family petition. After that gets approved, we have to take a bunch of other steps, and then we have to send your spouse outside of the US to a consulate so that he or she can go through an interview and re-enter the US as a permanent resident. If you haven't figured it out by now, this is highly complex, highly fact-specific, and I feel a little bit bad for being so harsh on my employee for asking such a reasonable question. Alright guys, so just to summarize, an application for adjustment of status includes filing the family petition usually. But if you're not eligible to apply for adjustment of status within the US, we would only file Form I-130. I assume that a lot of people are watching this video because they're trying to determine whether they should apply for a green card in the US adjustment of status or just file the I-130. Unfortunately, it's very difficult to figure that out without a ton of immigration law knowledge. So if you're trying to figure out what to do, the best thing to do is schedule a consultation with an attorney so at least the attorney can tell you what to do, even if you plan on doing it all yourself. I can't tell you how many times I have met with people who come to my office with an approved I-130. It took them like a year to file that form and get it approved, and now they come here to my office and they want me to apply for their green card, their adjustment of status. And at that point, I either tell them, you're not eligible for adjustment of status, we have to do a bunch of other stuff and then send your spouse outside of the US to consular process back in, or I tell them, you were eligible for adjustment of status all the time, all along. Why did you file this I-130 and waste a year? Your spouse could have their green card by now if we had just filed all the forms together. So it's a highly fact-specific inquiry. If you're interested in applying, or you have a family member whom you want to bring to the US or fix their status if they're already in the US, please contact me. You could schedule a consultation directly through my website and I could assist you. We'll go through your whole case from start to finish and figure out what the best plan is for you and your family. If you're new to my channel, be sure to subscribe. I put out a video on these immigration related topics focusing primarily on family-based immigration on a weekly basis, and I'll see you guys next week for another video.